So there are three common types of employment-related claims that lead to litigation. One kind of employment-related claim is when two people come together and there's confusion about whether one of the people is a business owner and a partner or just a mere employee. And there's differing views over the status of that person. Another kind of employment dispute is just where someone comes in as an executive, for example, with an employment contract, and whether each side, is meeting the terms of its contract. And one place that comes in a lot in Nevada is when there's a non-competition covenant or a non-solicitation covenant, and there's a dispute over what the departing executive can and can't do that's compliant with that non-compete obligation. And then a third type of employment dispute is just, the conditions of employment, whether there's any discrimination or violation of a federal or state law that protects employees from certain types of treatment or safety or discrimination or hostile work environment. That third kind, we don't really get involved in. We're more focused on the actual terms of a contract and whether they're being performed, particularly with respect to non-competition agreements. And we're also very involved in partnership disputes, even where one partner says, the other guy was just, an employee. So most businesses want to reduce the risk of employment lawsuits. One place to start is when you have an employment agreement, have that agreement reviewed by counsel, maybe even drafted by counsel, so that you as the business are protected, so that you know what you're getting from your executive or responsible person, and you have the ability to end the relationship if it's not working or if they're not performing. Another thing that's very important is to have an employee handbook and have that reviewed by your employment law attorney at least annually. Keep that updated and follow it. And then the third thing is actually to follow your procedures, have an HR department to get counsel and deal with things as they come up proactively. So one of the employment-related disputes that we see a lot in our office, from both sides, is when there's a business and then there's a trusted employee, and the trusted employee quits the business and goes into competition with the former employer. And there's always going to be questions there about whether the employee improperly diverted customers away from the business and whether the employee took valuable intellectual property and other property from the business as they walked out the door, and whether they are in breach of their agreement with the employer by doing these things. So a lot of times businesses are looking for ways to resolve employment disputes that don't require them to go to court. And there are a lot of employment-related disputes that do get resolved outside of court. One way they get resolved is through negotiation. And if there's a dialogue between the employee or former employee in the business, those can oftentimes be resolved. For some reason, if the parties are talking, they can usually work it out. Another way that may surprise you that employment-related disputes get resolved is just through stalemate. It's like it's just so much of a pain in the neck for the employee to pursue it, or a pain in the neck for the employer to pursue it, that they might communicate around it, they might send demands one way or the other, but neither party is motivated or has a strong enough case to take the next step, and you see a lot of stalemates in this area. If you as a business or a business owner have any questions about resolving employment-related disputes that come out of your business, give us a call at the Sierra Crest Business Law Group.